Listen, I'm doing fantastic this morning.
Well, first of all, explain to us what the court said yesterday and what that means to you.
Okay, so yesterday, the police wanted the demonstration stopped. They didn't want the demonstration to proceed as planned under the guise of terrorism. And when that failed, they told the court that they were unable to move the application because they were not prepared, with the intention that if the application was not moved, there could be no demonstration today. So the court heard us, and the court was of the opinion that because today is the day for the demonstration, it was only fair and just that the police moves its own application that filed, and that they could not hide under the guise of being unprepared to say that the demonstrators should not be allowed. So the court subsequently ruled on that and asked them to move the motion. Now, when the motion was moved, it appeared the judge was terrified about the alleged threat of terrorism in the sub-region. And so the judge said that the demonstrators have a right to demonstrate in accordance with the Constitution, and so the demonstration could go on, but proposed or ordered that some rules should be used, and said that the demonstrators should go through ARICE Code through TUC, then to Independence Square, as opposed to the original route of going through Nima and then to Flagstaff House. But in all these, it is important to demonstrate that, to say that the police demonstrated a lot of bad faith, because on the 23rd, whereas they were in court filing an application, they had met with representatives of ARICE Ghana, and they had reached a compromise on the route and also the time. And so both parties agreed that the demonstration was going to close at 8 p.m., only for the police to rush to court. And yesterday, they told the court that they wanted the demonstration to close at 3 p.m., but the court said it should rather close at 4 p.m. for day one. So that's just for day one. We were dissatisfied with the decision, although the judge thought she was granting the application in part. So we filed a notice of appeal to appeal against the decision, and we also filed a notice of stay of execution pending appeal. The substantive motion has been slated for the 12th of July. But you and I know the demonstration is coming up this morning. The organizers have instructed us that they will converge at a brass fort, and whatever happens, they'll take it from there. So that's by way of update.
Well, so first of all, I want to go back to the issue of, you mean the police main argument against the time you set for, the original time set or agreed for the demonstration. But before that, I think there's a point you made. You said earlier there was an agreement with the police that the first route, the original routes be used, the demonstration go ahead as planned, but you close at 8 p.m.
Mm-hmm.
That was agreement with the organizers of the demonstration.
So, yes. So, when the organizers wrote to the police indicating that they wanted to do a 48-hour non-stop demonstration and propose some routes, the police said they did not have the capacity to provide a 48-hour continuous security. And so there were agreements, and the organizers decided to break the demonstration into 2 days then. The first day from 12 p.m. to 10 p.m. The police were not excited about the 10 p.m. because they said it was too late, and wrote back to the organizers. So on the 22nd of June, the organizers wrote back to the police and said, okay, we've heard you, and so we would compromise. And then the director of operations invited the organizers to a meeting on the 23rd at the police headquarters Whereas they were in the meeting, apparently another lawyer of the police was in court filing at this instance application that the court heard yesterday on the blind side of the organizers. But before the organizers left the meeting, they all left with the understanding that because the police were not satisfied with the 8 p.m., with the 10 p.m., I beg your pardon, they were now going to change the time to 8 p.m. So both parties left with the understanding that we are going to start a demonstration from 12 and we are going to close at 8 p.m. Only for the surprise to be sprung on the second responder. But in all these, it's also instructed to say that ARICE Ghana was not served. It was only Bernard Mona who was served. And so yesterday when we were in court, we appeared in court for Bernard Mona alone because ARICE Ghana as the first respondent had not been served. But the motion proceeded anyway.
Oh, so the what was filed was against Bernard Mona?
Yes, it was against ARICE Ghana and Bernard Mona, but ARICE Ghana had not been served. And in law, when you've not been served, you are deemed not to have knowledge about the processes. So ARICE Ghana, they have not been served. And so we did not represent them in court yesterday. We only represented Bernard Mona.
I read a police statement yesterday where they were indicating that their only disagreement was with the closing time of the demonstration, that they found the 10 p.m. unacceptable. You are now telling me that when they ended up in court, they were fighting against the demonstration on the ground of terrorism?
Yes. In fact, those were the depositions contained in the affidavit in support that the demonstration, they did not want the demonstration to come up because there were threats of terrorism, because there were other security implications for the demonstration. And so yesterday, they did not want to move the motion under the guise that we had not served them with our affidavit in opposition. So the court stood down the case for 3 hours, 30 minutes for the police to read our affidavit in opposition. When the case was recalled, the police said that they had come across some depositions in our affidavit in opposition, and for which reason they wanted to respond. So at all costs, they wanted the case adjourned because they were not prepared, with the intention that while the matter was pending in court, the demonstrators could not undertake the demonstration this morning. But the court overruled it. And so the court, in its view, tried to do a balancing act. But we believe that in this country, demonstrations have taken place on the 9th. In this country, a lot of demonstrations have also taken place at the frontage of the Flagstaff House. What the organizers of the ARICE Ghana demonstration were even asking for was not to demonstrate at the frontage of the Flagstaff House, but a place close to it around the Christ the King, so that if the president was being briefed wrongly about the economic hardship in the country, that demonstration could have brought to his notice the kind of excruciating hardship that the people have been subjected to. But once again, this action is consistent with the current government's action on how it does not believe in human rights, how it does not believe that people's constitutionally guaranteed rights should be exercised as long as it gives government a bad name. And sadly so, that is the kind of republic we are in now.
So the proposed route has changed. Okay, so first of all, let me understand. The court says you go through Farisco, TUC, yes, end up at the Black Star Square, right?
Yes.
That's the court's proposed route.
Yes.
Now, you have indicated through a notice of appeal that you are not happy with what the court has decided. So you have filed a stay of execution, that notice of appeal. What does that mean essentially? Does that mean you can go ahead and use your original routes?
So there are two schools of thought when it comes to stay of execution. There is one school of thought that says that by filing the notice of stay of execution, it says the decision in itself. And so, pending that, the status quo will remain. There is another school of thought, and when I say school of thought, I mean decided cases. So, there is another school of thought that says that the mere filing of stay of execution does not mean that the status quo ante should remain. It means the judgment subsists. And so this morning, as lawyers who advise the organizers, we weigh our options. We'll look at how best we can air our views and allow citizens to also demonstrate without having to have any clashes with the police. But what I can assure you is that come what may, the demonstration is coming off. And our information is that they will gather at Opera Fort between the time 10 a.m. to 12 p.m. And at that stage, they'll make a decision. But as a matter of fact, the demonstration will come off this morning.
In some shape or form, but you will advise us to what's the best route forward as lawyers.
Yes, I mean, we'll advise on your legal options there, because there are two schools of thought. We'll advise on which school of thought we should subscribe to. So as it stands now, the stay of execution and pending appeal and the notice of appeal is not a closed game. So advise organizers on their options, and we've been talking and weighing our options from yesterday through to this morning. And so I'm sure by the time every member converges, sometimes the numbers will also tell, because they tell me they are expecting more than 6,000 Ghanaians to gather and air their views.
Well, that's okay. So we'll see what the decision is going forward. But key thing, demonstration comes off as planned.
Yes,
the demonstration will happen. That one.
The demonstration will happen.
Okay.
It's definitely the demonstration will happen.
Okay. Okay. So thank you. But before I let you go, one of the things the demonstration is asking for is the repeal of the E-Levy Act. I am sure you've heard what Gabi Ochridako has tweeted. Your views on it?
You know, I remember when when I was growing up, my mom used to tell me something, that an elderly person, no matter what, is farther than a priest. And so sometimes when you have been in government before and you understand the economic structures, you are better placed to make some decisions and to advise on some policies. And so any policy that seeks to impose further hardship on the people at a time when everything in the country is escalating will not be successful. Because since the E-Levy was passed, I hardly use mobile money. I always go to the ATM card, because we say that tax avoidance is no crime. It is tax evasion that is crime. And so if citizens have the option not to pay, even with the little they have, they will not pay. And the government did not listen. And you saw how much money was spent just to pass this E-Levy. I am very sure that even with the projected 60 million cedis that has been received, all may have gone into the preparation towards the implementation of the E-Levy Act, because you realize they were holding a lot of town hall meetings in various regions at the cost of the taxpayer. We are told that Adjoa Safo was given about 120,000 cities to come to Parliament, to come and vote for the E-Levy. They brought some of their members in Parliament in ambulances. They had to fly some members of Parliament by private jets. Of course, with the government that has the pension for luxurious private jets at £20,000 per hour. And so I am even certain that even with the 60 million cedis that has been raised, they've gone into preparatory work. So basically the government is back to zero. And so when you have a system like we have, when you have a situation where people are going through unprecedented hardship, this morning as we speak, unemployment is highest in 35 years. For the first time in the Fourth Republic, we've had to buy diesel for almost 61 cedis per gallon. It's never happened. I don't even think in the Third Republic it happened, and it happened in the Second Republic. So this is the first time in the history of our country that we have to go through these things. This is the first time in the history of our country that we had so much money during a pandemic, and it's been used in the most unconscionable manner. And so you will feel the effect. Nobody will want to pay it. Taxes to e-levy, for the president to fly private jets, for government officials to hold very big parties and sign very, very big contracts with the aim of not even seeing the contract implemented. And so I even expect the numbers to go low, because when the e-levy is implemented, people would not have found their way around it. But with time, people will find their way to avoid it. So I even project that the revenue will go low. And so we will be where we are if we have a government that will not listen, if we have a government that does not have the administrative capacity and the mental fortitude to solve the economic issues, we will be where we are. And it's going to get worse. I'm sorry to say, but the situation is going to get worse.
Well, thank you very much. Thank you very much for speaking to us. Of course, we'll stay, we'll keep coming to you for updates on exactly what happens. But thank you. Thank you for speaking to us this morning.
My pleasure.
Lawyer Beatrice Annan is a private legal practitioner. Yesterday was in court as a member of the legal team that represented Bernard Mona and ARICE Ghana. She indicated to us that ARICE Ghana was not served